So now we begin with the case law of Donogh versus Stevenson, this also known as snail in the bottle case. Appellant plaintiff Donogh drank a bottle of the ginger beer which was bought from a retailer by her friend. It contained the decomposed body of the snail, which was found out by her when she had already consumed a part of the contents of the bottle. Consumer of drink was allowed to bring action against the manufacturer between whom there was no contract. A manufacturer of goods owes a duty of care to the ultimate consumer. Lord Acton neighbor rule: you must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to cause injury to your neighbor. Next, the duty of care to the plaintiff, the legal duty rather than a mere moral, religious, or social duty. The plaintiff has to establish that the defendant owed to him a specific legal duty to take care of which he has made a breach. There is no general rule of law defining such duty. It depends in each case whether a duty exists. The essentials of this is the duty of care to the plaintiff, the breach of duty, and the damages, the consequential harm to the plaintiff. ये हिंदी में भी है इसको you can have a look once. The standard of the care required, क्या कहता है ये? Magnitude of the risk. The degree of care required varies according to each situation. What may be careful act in one situation may be a negligent act in another. The law does not demand the same amount of care under all situations. The kind of risk involved determines the precautions which the defendant is expected to take. The famous case law is Nitin Walia versus Union of India, year 2001. The child visitor of Delhi Zoo, aged 3 years, put his hands inside the iron bars where a tigress was kept and his hand was crushed by the tigress. It was held that the zoo authorities should have put iron mesh on the rods and were liable in damages for the injury, and the child wasn't guilty for any contributory negligence. Now, we have the same standard of the care required. Then, point number one, the importance of the object is to be attained. The law does not require greatest possible care, but the care required is that a reasonable man under certain circumstances. The law permits taking chance of some measure of risk so that in public interest various kinds of activities should go on. The famous case law is Latimer versus AEC Limited. Latimer versus AEC Limited. Due to heavy rain, a factory was flooded with water, which got mixed with some oily substances. The floors in the factory became slippery. The factory owner spread all the available sawdust, but some oily patches still remained there. The plaintiff slipped and was injured. He sued defendants and contended that, as a matter of precaution, the factory should have been closed down. Breach of duty. The breach of duty means non observance of due care which is required in a particular situation. The standard is that of a reasonable man or of an ordinarily prudent man. If the defendant has acted like a reasonably prudent man, there is no negligence. Now we have the essentials. What are the essentials? The injurious agency was under the management or control of the defendant. The accident is such as ordinary cause of things doesn't happen if those who have the management use proper care. There must be no evidence of the actual cause of the accident. The case law is Briney versus Broadley. Briney versus Broadley. The plaintiff was going in a public street when a barrel of the floor fell upon him from the defendant's warehouse window. There was no evidence on the part of the plaintiff as to how the accident happened, beyond the fact that while on the road he was knocked down by the barrel, became unconscious, and was injured. Want of care on the part of defendant was presumed, and it was for him to show that the same was not for want of care of his parts. For the barrels do not usually fall down out from window unless there is a want of care. Same thing mentioned in Hindi also. अब देखते हैं हर्जाना, which is also known as damages. What are damages? It is also necessary that the defendant's breach of duty must cause damage due to the plaintiff. The plaintiff has also to show that the damages thus caused is due not to remote a consequence of the defendant's negligence. Res ipsa loquitur. Proof of negligence. The Latin term res ipsa loquitur means the thing speaks for itself. The thing speaks for itself, which also means the situation of a particular act is not is enough to get the idea what has happened. It is the principle that the mere occurrence of some types of accident is sufficient to imply negligence. Burden of proof is shifted from the plaintiff to the defendant. Instead, to the plaintiff proving negligence, the defendant is required to disapprove it. Now, we have the further one. Standard of care required. We saw na earlier point number two, then point number one. Now there is point number three. The amount of consideration for which service etc. are offered. क्या क्या है? The degree of care depends also on the kind of services offered by the defendant and the consideration charged therefore from the plaintiff. Same thing is also mentioned in Hindi. अब क्या होता है? Plaintiff need not be in the area of physical injury to himself. It is enough that he is so placed that a shock could be caused to him by seeing or hearing something. The case law is Borhill versus Young. Borhill versus Young. The plaintiff should be so placed where injury through nervous shock can be foreseen by a reasonable man. He has to show the necessary chain of caution between his psychiatric illness, which is also known as nervous shock, and the death or injury of one or more third parties caused by defendant's wrongful act. Physical injury isn't necessary. फिजिकल इंजरी हो ऐसे ज़रूरी भी नहीं है. Next point. Under case of nervous shock, the plaintiff has to prove following things, which we read it above. क्या क्या? Rational body is controlled by its nervous system, and if by reason of an acute shock to the nervous system, the activities of the body are impaired and it is prevented from functioning normally, there is a clear bodily injury. Also, causing of nervous shock itself isn't enough to make it an actionable tort. Some injury or illness must take place as a result of emotional disturbance, fear, or sorrow. This branch is comparatively of recent origin. It may be caused by words or act of the defendant. It may be induced by some accident due to the defendant's negligence or on account of false statement willfully made or due to intimidation. The nervous shock, nervous shock आता है nervous shock क्या होता है nervous shock literally means shock of the nerve and brain structure of the body. It provides relief when a person may get physical injury not by an impact, example, by stick, bullet, etc., but merely by a nervous shock through what he has seen or heard. Now, same thing आप हिंदी में देख सकते हैं. After the body of the motorcyclist had been removed, the fish wife happened to go to the scene of the accident and saw the blood on the road. It resulted in the nervous shock. She was 8 months pregnant when she gave birth to the child. He was stillborn. The case law is of the Boar Hill versus Young. We read it above right away. Motorcyclist, while negligently driving at an excessive speed, collided with a motor car was killed. The plaintiff, a fishwife, standing about 45 feet from the point of impact, heard the noise although she didn't see the accident. When told by some bystanders that a child answering the description of one of her children had been injured. What? Been injured? She suffered nervous shock, which resulted in her death. Defendants were held liable even though she wasn't in the area of the physical injury. The lorry started off by itself and ran violently down the incline. The plaintiff's wife, who had been walking up the street with her children, had just parted with them. When she saw the lorry, she became very frightened for the safety of her children, who by that time were out of sight. Which case law it is? This is the case law of Hambrook versus Strike Bros. Hambrook versus Strike Brothers. जिसको हम ब्रॉस कहते हैं brothers short form. It isn't necessary that shock must be such as arises from reasonable fear of immediate personal injury to oneself. Defendant's servant left a motor lorry at the top of the steep street unattended with the engine running. He was a crazy guy, man. Now, what happened? A pregnant woman, plaintiff, was standing behind the bar of that house. The plaintiff, in consequence, sustained a nervous shock and became seriously ill and gave premature birth to a child who was born idiot. Defendant was held liable. This was overruled in Hambrook versus Strock Brothers case. Next case law is Dulio versus White. Dulio versus White. क्या था इस केस लॉ में? Shock must be such as arise from reasonable fear of immediate personal injury to oneself. The defendant's servant negligently drove a horse van into a public house. What happened after that? The damages for nervous shock were not limited to psychiatric damage resulting from witnessing personal injury but could be recovered where the plaintiff witnessed destructions of his property caused by defendant's wrongful act. Atia versus British Gas, historical डेवलपमेंट ऑफ नर्वस शॉक, जिसको हम पीएलसी भी कहते हैं, ठीक है, दिस अटाया अटिया वर्सेस ब्रिटिश गैस पीएलसी, द हिस्टोरिकल डेवलपमेंट ऑफ द नर्वस शॉक लॉ क्या था, इस अल्कॉक्स केस। अल्कॉक्स केस क्या है? plaintiffs who suffered a nervous shock when disaster at football match was televised live and in news bulletins but without depicting the suffering or dying of reasonably recognizable individuals were held not entitled to damages. This is all mentioned in Hindi. अब हम आगे देखते हैं. The plaintiff will have to show close relationship of love and affection with the primary victim, and also that the proximity to the accident was sufficiently closed in time and space. However, it has been that the primary victim need not be a near relative of the plaintiff, like crane driver. The plaintiff suffered a nervous shock when he saw that by breaking off a rope of crane, it fell into the hold of a ship where some men were at work. The case law is Dooley versus Camel Laird and Company. Dooley versus Camel Laird and Company. The defendant was liable there has to difference between primary victim and secondary victim. In claim by secondary victim, law insists to limit the number of potential claimants. आगे देखते हैं हम लोग. The plaintiff who was involved in a motor accident due to negligence of the defendants didn't suffer any physical injury. He, though in a position of primary victim, being directly involved in the accident, remained unhurt. However, he suffered myalgic encephalomyelitis, a psychiatric illness with which he had earlier suffered, but which was then in reminiscence. The skull or the eggshell skull rule. Thin skull और द एक्शेल स्कल रूल क्या कहते हैं? पहले तो केस लॉ देखते हैं. पेज वर्सेस स्मिथ. Once it is shown that some psychiatric damage was foreseeable, it doesn't matter the claimant was particularly susceptible to psychiatric illness. The defendant must take his victim as he finds his and pay for all the consequences of nervous shock. A person can claim damages for nervous shock which he suffers on seeing the aftermath of the accident after being told about the accident. But for that he will require existence of close relationship of love and affection, that all was already mentioned above, and close proximity in time and space with the accident or its aftermath, which is also known as Alcock's case. The defendant was liable as the nervous shock suffered by her was a reasonably foreseeable consequence of the defendant's negligence. The House of Lords allowed the plaintiff's claim for damages for nervous shock even though she was not at or near the scene of accident at the time or shortly afterwards. After being told about the accident, she was taken to the hospital and she saw the injured husband and children and also heard about the death of the daughter. She suffered severe nervous shock. What is aftermath doctrine? The case law किसे समझाते हैं? MC Loughlin versus O'Brien. MC Loughlin versus O'Brien. क्या होता है इसमें? The plaintiff's husband and three children were involved. How many children? Three children were involved in a road accident which was caused by the negligence of the defendants. One child was killed and the husband and the other two children were severely injured. Plaintiff at the time of accident was 2 miles away. Ear shot doctrine. क्या कहते हैं doctrine? Near relatives who might have witnessed the accident but was within earshot yani vicinity and likely to come upon the scene can claim for nervous shock. In Hinds versus Perry, a mother witnessed a horrifying and tragic accident to her family from the other side of the road can claim. The defendant wasn't liable. Court held that a man isn't negligent in the air. The duty arises only towards those individual of whom it may be reasonably anticipated that they will be affected by the act which constitutes the alleged breach. In the present case, plaintiff wasn't involved in the accident and she even didn't see the accident, being far away from it. It is mentioned in Hindi. Now, the rescuers, such as firemen, policemen, and volunteers who put themselves in the way of danger and suffer psychiatric shock as a result, used to be primary victims until the decision. White versus Chief Constable of the South Yorkshire Police explained that the rescuers had no special position in the law and had to prove reasonable fear as a consequences of exposure to danger. Rescuers invariably come within a category of secondary victims and special provisions have more difficulty recovering damages than primary victim. The shock must be a sudden and not a gradual assault on the claimant's nervous system, so a claimant who develops a depression from living with a relative debilitated by the accident will not be able to recover damages. However, the case of the pure psychiatric illness caused by stress inducing work have also begun to surface. Case losses, Alcock's case. ये हिंदी में लिखा हुआ है, आप इसको गो थ्रू कर सकते हैं once. I'll explain in English. What the cases? Witnessing events on TV at home or heard from radio, the House of Lords rejected such claim as it doesn't satisfy the test of proximity. However, it isn't totally ruled out. Similar example of this is a spectator at a car race who witnesses a terrible crash caused by negligence on the part of the car manufacturers and develops a nervous shock or nervous illness as a result of his experience. It is in these cases, it is in these cases where the courts have been particularly reluctant to avoid damages for nervous shock. And hence, over here, our tort law is done. Thank you. Now we'll begin with the next subject.